the definition of torture and crimes against humanity. We want to hear what people have already done about it. That's why we have Kajal here to talk about the South African experience and what might happen next. And then thirdly, we want to learn a bit more about universal jurisdiction. The idea of universal jurisdiction is the idea that if a crime so serious as torture or crimes against humanity is happening in one country, then every country has a duty and a responsibility to take action about it. And if the solution can't be found in Zimbabwe, then it may be necessary to look at other countries. I'm sure that some of you are thinking, what's a white European woman doing sitting in the chair? But the reason is very much to look at the cases that are being brought in Southern Africa, that are being brought by Zimbabweans and by Zimbabwean and South African lawyers. And that's really the starting point for tonight's discussion with as British lawyers to talk about our experience, and hopefully we can exchange experiences and find a way of having impact on the situation in South Africa. So thank you for joining us. If you haven't already got the link from for the Zoom call, if you're just listening on Facebook, then you can join us by going on to Zoom. The ID is 824-8784-6300, and the passcode is 539000. And if you do join the Zoom call, then hopefully you'll be able to send in your questions, and we'll be able to have some time for questions in the middle and at the end of the talk. Okay, so I'm very proud to be welcoming Hilton Tamangani now, and you'll understand why when you hear what he's got to say to us. Over to Hilton.
Thank you very much, Sue, and greetings to everybody. I'm going to present to you a topic that is very painful to my heart. Each time I reflect on any of the aspects of this topic, my heart bleeds with pain. Nevertheless, I am grateful to be here, and I give special thanks to Zimai. I give special thanks to Sue Willman, alongside Dayton, Pierce, and Glenn. I am cognizant of the fact that you guys feel my pain. That's why you do all this hard work. I am cognizant of the time limit, so I'll try to speak with speed. My presentation is based on history, a history that started on the 12th of October, 2019. That date was also the 29th birthday of Little Hilton. I am therefore able to take the opportunity. I can take the opportunity to look at a full story which has already happened, and I can draw conclusions from what has already happened. Just a quick word based on who was Little Hilton. Little Hilton was the last born in my family. I was blessed with 7 children, and Little Hilton was the last one of them. I share the same name with him, the same first name. That's why I used to call him Little Bill Hilton. I was just saying, this young man is a little me. Little Hilton was a vibrant young man. He lived in a blessed life, a vibrant life. He lived his life mostly among his friends. A typical day for Little Hilton would have been he woke up at 5 a.m. in the morning, prepare himself for going to work, and go out to work and spend the whole day working. At the end of the day, he will go along with his friends and socialize with his friends and come back home just before midnight. That was Little Hilton. I had big plans for Little Hilton. Little Hilton himself had big ambitions. He had so many things that he wanted to do. Now, what happened in the middle of all that was that earthly rulers hatched a plot to eliminate Little Hilton. Their plot was based on hatred, and implementation of their plan started on the 12th of October, which, as I said, was Little Hilton's 29th birthday. Their plan was to inflict life-threatening injuries on Little Hilton. So by the time they left to go to where they knew they would find Little Hilton, they armed themselves with baton claps, with heavy duty boots. Those were their tools for the murder of Little Hilton. So when they arrived, when they saw where he was, the baton claps went into action, the heavy duty boots went into action. They stepped on all his body, they kicked his body, including his head. They were stepping and kicking on his head. So by the time they finished doing what they wanted to do, Little Hilton could hardly walk because of pain, because of wounds. The next part of their plan was to deny Little Hilton medical attention. So they took him to Harare Central Police Station and closed him up there. Nobody had access to him, including relatives, even close relatives. Nobody had access to him. And all medical personnel, ambulances were sent at some point from a hospital, nearby hospital, to treat them, to treat Little Hilton while he was there in the police station. And that permission to medically treat Little Hilton was denied. The third part of their plan was to allow Little Hilton's vital organs time to shut down. When wounds go untreated, they become septic. When septic wounds continue to be untreated, the whole body becomes septic. That's what they wanted to happen to Little Hilton when they were denying him medical attention. So his vital organs shut down, and then that was the cause of death. And it took them 7 days to do that. When this is the type of death which when you look at it from a post-mortem point of view, it will show as death from unknown causes, and it will appear as if it's a natural death. That is what happened to Little Hilton. What that teaches me, looking in retrospect to what happened to Little Hilton, I now know that there is a culture of evil operating in Zimbabwe, demonic evil. What happened to Little Hilton cannot happen unless there is the presence of the devil. Without the devil, no one will be able to do such a thing to a fellow human being. Having said that, I must mention that this is not a problem that happened to Little Hilton alone. A lot of people have died in Zimbabwe under similar conditions, the circumstances, before Little Hilton died. Even after Little Hilton, a number of people, quite a lot of people are dying under similar circumstances. And also, this is not a problem that is happening in Zimbabwe only. From other communications, I know that this is happening in many parts of the entire world. That's the story. Thank you very much.
Thank you, Hilton. I realise it'd be very painful to talk about your son's arrest and mistreatment by the police, and then him being denied medical treatment in jail and in the police station. But tonight, hopefully, we can talk about ways in which we will ensure that this doesn't happen again. So we were lucky to get in touch with Kajal Ranjathan Kiev through a Zimbabwean lawyer who himself has been tortured, through Gabriel Shumba, who was involved in the same case. It's very unusual to get a case on universal jurisdiction into court. And these lawyers have not only got the case into court, they've won the case in the South African Constitutional Court. Kajal is a law graduate from the University of Natal. She comes to this area of international human rights through her work on migration, and we're very proud to have her here tonight. And I'll let her talk about the case and the aftermath of the case as far as she can. Thank you.
Thanks, Sue. So I'm going to give you a brief overview of the case which we ran in South Africa several years ago. And the case name is the Southern Africa Litigation Center and the Zimbabwe Exiles Forum versus the National Commissioner of the South African Police Services. SALC and ZEF, the Zimbabwe Exiles Forum that Gabriel Shumba is with, worked very closely on developing a dossier, which was then presented to the South African Police and the National Prosecution Authority, which set out a range of allegations of torture, which amounted to crimes against humanity committed in Zimbabwe. And the National Prosecution Authority and the police services refused to accept that they had any obligation to do anything because the crimes were committed in Zimbabwe. So in October 2014, the South African Constitutional Court, this was the final outcome of the case, held that the South African Police Service have a duty to investigate allegations of crimes against humanity committed in Zimbabwe by Zimbabweans against Zimbabweans based on the allegations detailed in this dossier, which was compiled by SALC and ZEF. And the court also ordered the police services to begin investigations without further delay. The case was initially filed in 2008. It spent 6 years before the South African court system. So it went through the High Court, the Supreme Court, and eventually the Constitutional Court, where it was eventually successful. And it has now been 6 years since we received that outcome in the Constitutional Court. It has been a challenge to get the police to start the investigations. Those investigations have now commenced. They are ongoing, and I'll talk a little bit more about them in a while. Central to that Constitutional Court judgment are the following issues. In terms of international and domestic law, which is South African law, the presence of the suspect was not required for investigations, but the presence of the suspect is required for prosecution. So what the court was saying is that the South African police may investigate any perpetrators for crimes committed in Zimbabwe. These are crimes against humanity. Even if that individual was not present in South Africa, they could continue and finalize that investigation. But in order for prosecution, that individual needed to be in South Africa. And then the second issue was that universal jurisdiction is applicable, but must be subject to principles of subsidiarity and practicability. The court drew a clear distinction between investigation and prosecution of international crimes on the basis of universal jurisdiction, whereas the dominant position in international law suggests that the presence of the accused is required the presence of an accused in a state is a prerequisite to prosecution. There is no such presence requirement as a prerequisite to investigation. And that is actually a very important position for all of us currently, as well as in relation to the case which we brought. In terms of domestic law, the court held that the Constitution requires the presence of an accused during their trial, and that it is silent on whether the presence was required for investigation. So in the court's view, the exercise of universal jurisdiction for the purposes of investigation of an international crime committed outside South Africa's territory may occur in the absence of a subject without violating the Constitution or international law. The court also noted for several reasons that following this approach, the presence requiring the presence for an investigation would render South Africa's attempts to combat extraterritorial crimes against humanity as futile, because it would not be practicable to initiate charges or prosecution against an accused who is only temporarily within the state without a certain level of prior investigation. So the judgment links the different types of jurisdiction to universality, which was an integral component of that case. The judgment also indicates that universal jurisdiction to investigate international crimes is not absolute and is subject to at least two limiting principles, which is subsidiarity and practicability. I won't go into those details for the purposes of our discussion tonight. But what the court made a firm statement on was that it wanted to be clear that South Africa could not be a safe haven for perpetrators of crimes against humanity, and that the country must honor its international and domestic law commitments. And it found that the South African Police Service's refusal to investigate was wrong in law, and the court dismissed the police service's appeal and ordered that investigation to commence immediately. The South African police have, and this is very clear from the case, are unable to travel to Zimbabwe for the purposes of continuing the investigation. So they have had to do all of their investigation in South Africa, and that included consultations with witnesses. So witnesses have had to travel from Zimbabwe to South Africa for the purposes of assisting the investigation, and that accounted for a very slow investigation process. But slow doesn't mean it's impossible. That process is nearly completed. So the case has had a very strong and positive outcome in terms of universal jurisdiction for the prosecution of crimes against humanity committed in Zimbabwe. But in practical terms, the case took 6 years before South African courts, and the investigation has now taken 6 years outside of the court. So that is a 12-year period to investigate a particular set of facts and a particular set of allegations, so which is an extremely long time. And of course, it was the first case of its kind dealing with these kinds of crimes against humanity and universal jurisdiction issues, so that is understandable. I'm aware of several other cases and investigations which are ongoing at the moment, which have followed a similar path based on the outcomes of that very important case. And it's entirely likely that those cases may be finalized before this particular case is finalized. But of course, it would not have been possible without that first case and without that first investigation. Sue, how am I doing for time? And can I talk a little bit about that case?
Yes, carry on, you're fine.
Okay, all right. So to give you a short overview about how that particular case came about. So the events that led to the case relate to the 2007 Zimbabwe elections, where the Zimbabwe police raided the opposition party, the MDC headquarters, and detained and tortured suspected and actual MDC members and activists. As a result of South Africa's obligations under the Rome Statute, SALC and ZEF delivered a dossier to the NPA and the South African Police Services containing this comprehensive evidence of about the involvement of a number of Zimbabwean officials in the perpetration of widespread and systematic torture, which constituted a crime against humanity. And that was the basis of the investigation. And the suspected perpetrators and the victims in the case are not. The public documents and the public record of the case have removed the names of the perpetrators and the victims in order to protect the investigation process from being hampered. So there are individuals who are under investigation who have no idea that they're under investigation. And the victims of torture were mostly members of the opposition party or individuals perceived to be members. And the case obviously involves incidents of state-sponsored violence, similar to what we have been seeing in the last weeks and in the last years, and certainly in the last 12 years since that case had commenced. What else would be important? I think I'll stop there and leave the rest for questions. Thank you.
Okay. Yeah, it's hard to overstress how important this case is. It's not just important in Southern Africa, it's of kind of universal worldwide importance. There are so few cases on this subject. So it's an amazing achievement. I think it shows the importance of very carefully collecting the evidence and the courage of the survivors of torture and their relatives, people like Hilton, who have stuck with the process for the past 12 years. But I wanted to ask you, Kajal, whether you feel kind of hopeful and positive about the process, that it can have an impact on the situation in Zimbabwe.
I think the process can have a very positive impact, particularly if prosecutions actually do commence. The court was mindful that, and it said that prosecutions in South Africa could only happen if prosecutions were not possible in Zimbabwe. And we know prosecutions are not possible in Zimbabwe, so it's vitally important for prosecutions to commence in South Africa and in any other jurisdiction which is able to sustain those kinds of investigations and prosecutions. So if the UK is looking to support Zimbabwean victims through universal jurisdiction, that would be fantastic. And it has a good basis to do this based on the South African case. But the Zimbabwean courts have not shown themselves to be independent. We've seen this in the last 2 weeks regarding bail hearings of the individuals who've been arrested. And if Zimbabwean courts are not willing to step up and show their independence and show us that they have a backbone, these prosecutions must take place outside of the country.
Thank you. So just for those who are listening on Facebook that would like to join in the Zoom and maybe ask them questions, again, the meeting ID is 824-878-46300 and the passcode is 539000. We are a bit behind time. I don't know if any of my colleagues have got any questions or whether Simba is going to come in with questions from ZimI. But before I go to that, I'd just like to ask you, Hilton, having heard from Kajal, I wondered, how that feels to you and whether that makes you feel differently about the future.
It feels very good, so considering that in our brainstorming that other day and many other days, we were sort of not clear on our way forward. But this sort of offers a viable way forward. In that sense, it is good for us. I feel quite good about it.
Thank you. Is there anyone else? Dua, I don't know if you have any thoughts about this, how Human Rights Watch see these developments of the actual prosecution in South Africa, if there's anything you wanted to add at this stage.
Thank you. I wish to strongly agree with Kajal and to acknowledge the great and groundbreaking work. And also, particularly as Human Rights Watch, we have been investigating human rights abuses, serious abuses in Zimbabwe. And I can concur and confirm that the justice administration system in Zimbabwe is compromised. It is not independent. And therefore, in terms of domestic remedies in Zimbabwe, it is not possible. And secondly, that there is an unwillingness by the prosecution there to take up human rights issues. So this is why I would also be strongly supporting the action by SALC and the Exiles Forum in South Africa. Thank you.
Okay, so I think we'll leave it there. Kajal, thank you so much for joining us. We've dragged Kajal in from her holiday, so I don't know if she can stay for the rest of our time, but hopefully we'll be keeping in touch and working together. Thank you so much. And now we're going to hear from Kirsty Brimelow, who is a barrister in the UK known as Queen's Counsel. She's going to explain a bit more about what universal jurisdiction means and what we've been trying to do in the UK along the lines of what's been happening in South Africa, but maybe a bit further behind. Go ahead, Kirsty.
Thank you. Thank you very much for inviting me to this panel. And obviously, the accounts that have gone before, so moving, but also hopeful in terms of the case which concluded in South Africa after 12 years of struggle. And the point I would really start with is that these cases do take a long time. However, it's quite interesting that some of the recent academic surveys and reports are showing an increase in the use of universal jurisdiction. I'm going to focus on the UK, specifically on the jurisdiction of England and Wales, which is where I practice. And I'm going to outline what crimes against humanity means and how it has to be distinguished from individual acts of crimes which are violating somebody's human rights. And also I'll talk a little bit more about the practicality, really from a practitioner's perspective, of how you can bring a case to prosecute in the UK. Now, there's been 3 cases in England and Wales using universal jurisdiction. The most recent case was Agnes Taylor, the former wife of Charles Taylor, and she was charged in 2017 with a number of torture charges relating to alleged incidents which were said to have taken place in the civil war in Liberia in 1990. There's a couple of interesting points coming out of that case. It did result in an acquittal on the basis that the court found before the trial started that there was a lack of evidence that the Taylor regime had government control over the particular areas where the alleged crimes had taken place. But the other interesting point out of this case is an interlocutory decision from the Supreme Court, which confirmed that torture can be carried out by those acting in a quasi-official capacity. So not necessarily those who are within the employ of a particular state or government. And previously, there's been a lot of jurisprudence around the position of somebody that you are bringing the case against. So that was an important case in the Supreme Court, and one which the effects of which will spread across other countries. Now, in the time I have, moving on to the case that went to trial, that was a case of Colonel Lama, which was the one before Agnes Taylor. And that went to trial in the summer of 2016. And he was alleged to have committed torture against prisoners in Nepal in 2005. He was acquitted by a jury. That case is interesting for a perspective of learning as to difficulties faced by the prosecution. And they included issues with having an interpreter in the, amazingly enough, actually in the appropriate language. And the first trial was abandoned on the basis they didn't have the right interpreter. And also issues really around the managing of witnesses who were really from almost a different world to a jury that had been brought together at the Old Bailey in London. The case in itself was interesting in that it did actually go right the way through to trial. There were lessons also to be learned from the way the evidence was gathered by the NGO in Nepal. And during the case, there was a lot of challenge to the NGO itself as to how it taken the statements and whether, in fact, it was influencing, either deliberately or unwittingly, actually influencing the accounts given by the alleged victims. The first person to be convicted under universal jurisdiction in England and Wales was actually an Afghan warlord. And this is back in 2005. So we have a long gap between the first case and then the next one coming through to trial with Colonel Lama. And the conviction there was for crimes in Afghanistan between 1991 and 1996. Now, a little bit about the law. In the UK, universal jurisdiction in respect of torture or crimes against humanity is empowered by a domestic statute. And just considering torture, those are the cases that we've considered so far. That domestic statute is the Criminal Justice Act, and it's 1988, and it's section 134, which provides that a public official, whatever his nationality, commits the offence of torture if in the United Kingdom or elsewhere he inflicts severe pain or suffering on another in the performance or purported performance of his official duties. So you could probably understand now why that Supreme Court decision is so important when it's ruled that a quasi-official also will be within a person who can be prosecuted under this act. The addition there is the acts have to be intentional. So, summary of universal jurisdiction. It's only applicable to the most serious international crimes, such as war crimes, genocide, and crimes against humanity. How's it working? Well, it's increasing, as I've said, but universal jurisdiction should be a last resort, and where the state with the territorial jurisdiction is unable or unwilling to prosecute. Sometimes you hear people referring to it as prosecute or extradite. And that really is a pithy summary of where universal jurisdiction comes in. And that the reason behind that is that the lawyers, and no doubt a lot of NGOs amongst you will know, is the aspect of the respect of the sovereignty of a nation state. Now, just moving on to what happens, the procedure in this jurisdiction, it involves contacting the War Crimes Unit, and in this jurisdiction you need the consent of the Director of Public Prosecutions in order for a prosecution to commence, and guidelines are considered. Now, within England and Wales, taking into account even the new judgment in South Africa, one of the aspects that would be considered in England and Wales is resources, and you have a restriction also of needing the person present in the country for the prosecution. And frankly, if the person isn't present at point of investigation, you are highly unlikely to get an investigation moving unless you can show that they are going to be present very soon, because otherwise it would be asking for a prosecution and resources being put into that prosecution really on a hypothetical basis that at some point a prosecution might be able to progress if sufficient evidence was put together. So the South African judgment probably would not make much difference to the situation in England and Wales. However, it's a positive step, and it's always very useful to have. And judgments in South Africa, certainly I use them in argument. And the thing with universal jurisdiction is you're able to use judgments from other countries. I should add that Spain, France, and Finland have actually also expanded their own universal jurisdiction to include terrorism. We've seen a lot of movement with the states that are actually using universal jurisdiction, with countries such as Germany, Sweden, actually Finland leading the way. There are, in the time I have left to me, I would recommend to you to look at the work of Devika Hovel, and she wrote, it's only slightly out of date, she wrote a report which went from looking at universal jurisdiction from 1961 up until May 2018, and she really did a comprehensive survey on those states that had completed universal jurisdiction trials. And so up until May 2018, there was 52 completed universal jurisdiction trials worldwide. And she also looked at the trend, and she was looking at the trend in customary international law, which is quite important for the lawyers amongst us. The other report I'd recommend to you is more recent, slightly more recent. It's by Trial International. A lot of you will be familiar with it, on universal jurisdiction, which did publish an annual review. And this is looking at the trials last year under universal jurisdiction. A few headline figures for you. There's an increase in 18% more named suspects than the previous year. There was 19 charges of crimes against humanity, 90, 111 war crimes charges, 42 torture charges. And we can see a spread with Germany in particularly issuing warrants and prosecuting in cases for international crimes in Syria, including non-state armed groups are being investigated currently in Germany. The final point I would ask you to take away at this stage is, what is a crime against humanity? Well, it's important that the definition is borne in mind when considering the crime that is being considered. And in summary, it's the crime must be committed. It's in furtherance of a state or organizational policy to commit an attack, and it includes physical elements such as murder, torture, imprisonment, and a large number of others. But also the context is one which is large-scale violence, and that can be in number or geography. And it has to be also either large-scale or systematic. And so you're looking therefore at the methodology. So that would exclude isolated acts, even though in themselves those particular acts are of real gravity and a crime against humanity in themselves. I'm probably going to just stop there, Sue, to allow for other questions on it. But if I can just finally say that the only restriction is the barriers, the restriction on universal jurisdiction inevitably is on evidence collecting, on legislation itself within states. The majority of universal jurisdiction prosecutions are being carried out where there is domestic law within that particular country. There still is a reluctance to carry out the prosecutions under international law, under the treaty itself, say the Convention Against Torture, rather than under a domestic law. And barriers include, for example, restrictions in many states, such as the requirement, it's already been touched upon, that the accused is physically present in that territory.
Kirsty, thank you so much for putting it all into context. Kirsty's a criminal lawyer in the UK, so she's very familiar with this area and she's worked on universal jurisdiction cases herself. I think we'll move now to Dua and then we'll come back for questions at the end. So Dua Mahinga is a lawyer, Zimbabwean. Previously, he worked at Zimbabwe Democracy Institute. He's now at Human Rights Watch. We've been talking about evidence. We really need organisations like Human Rights Watch who take the risks of going into countries and documenting what's happening in very careful detail in order to be able to bring these cases. And I hope he's going to set all the discussions that we've had so far into context. Over to you, Dua.
Thank you so much, Sue, for this opportunity. And I will speak briefly and broadly on our work investigating human rights abuses in Zimbabwe, particularly under this new dispensation of President Mnangagwa since November 2017, to look at the really rising number of human rights abuses. But I want to maybe highlight a common challenge, which is that perhaps when you look at evidence gathering investigations at a local level, for example, in Zimbabwe, I think there is an urgent need now to perhaps with support and engagements with groups like the Southern African Litigation Center to look at sort of common and agreed standards of research methodologies and information gathering, so that we can get to a point where, even as we are recording for the local groups, for citizens or for opposition groups or for journalists, that kind of evidence that is gathered can be used in a court of law and has got, the necessary information already contained in it, so that when there is a challenge, it is much easier when from the outset there is a view when gathering information that information can be used or might be used in a court of law in a process of prosecution. As Human Rights Watch, we have found that President Mnangagwa's government has used serious abuses. Security forces have been involved in abuses that include rape. So, for example, in January 2019, Human Rights Watch documented more than 17 cases in which women were raped as part of a crackdown on protesters and citizens in Harare and Chitungwiza and the neighboring sort of dormitory towns of Epworth. And these were soldiers, sometimes in uniform, and the victims were in a position to clearly identify because the soldiers were armed, they were driving military vehicles, and they spoke of the rape or the sexual assault as a form of punishment. And I spoke to women who had, following the attacks, the rape, gone to the local police stations to make formal reports. And frequently, the response was that the police would refuse to take those reports. And the refusal was on the basis that, well, it was happening across the country, it was happening everywhere, and the police would not involve themselves. And this particular point was also common around 2008 during the electoral violence, where the police almost took a national position that they would not receive any matters that were deemed to be political. And this included political violence, political killings, murders that were taking place across the country. And in many of those, security forces, soldiers, and the police were implicated and to date have not been held accountable. Sometimes it was the ruling ZANU-PF party supporters who were implicated, but who acted with impunity because they said they knew that the police would not get to them. So the issue of the state institutions being compromised begins with the police station where victims should be going to report. An issue related to that is the more recent phenomenon, which is also spreading, which you alluded to, so which is the abductions, torture, and sexual abuse, sexual assaults of activists, of opposition activists, and suspected or perceived government critics. We have had several leading activists being subjected to this treatment. Some of the high-profile cases include Obet Masaraure, who is the leader of the Association of Rural Teachers Union in Zimbabwe, who was abducted by armed people from his house in Waterfalls in Harare, tortured, severely beaten, including on the soles of his feet, and then dumped at Harare Central Police Station. The same applied in August 2019 to one Tatenda Mombeyarara, an activist with Citizens Manifesto, who was also abducted from his home, severely beaten, including on the soles of his feet, and his abductors were armed individuals who spoke with authority. They had weapons, AK-47 rifles and other guns that they were carrying, and they broke his leg, they broke his fingers, they tied his hands and threw him in a pond, only managing to escape when they had gone. We also had comedian Gonyeti Samantha Korea, who had done skits poking fun at the authorities. She was abducted from her home and severely beaten up, made to drink sewage water, and then dumped by the roadside. Again, we had the more recent case of the 3 young women activists from the opposition MDC Alliance, Joanna Mamombe, the Member of Parliament, Cecilia Chimbiri, and Netsai Marova. On May 13, after taking part in a peaceful protest in Warren Park in Harare, they were within the premises of a police station, abducted by unidentified individuals, but who are clearly linked to the state, and then driven away and tortured, sexually abused, including the individuals inserting the sharp ends of the guns into their private parts, and then dumped, and then eventually arrested by the police and charged with faking abductions and charged with participating in protests. So this is spreading, it's happening. We also have the case of the leader of the doctors union, who had been organizing protests last year and was abducted and tortured over 4 days in a place that he has no recollection. And part of the torture included administration of electric shocks and injecting into his body unidentified unknown substances. And this has also happened recently, just last week, with Tawanda Mchehiwa, who is the nephew, 22-year-old nephew of ZimLive editor Mdudus Matutu. The police had gone looking for this editor, Mdudus Matutu, could not find him, harassed his family, and then picked up his nephew, subjected him to this abuse and torture, injected him with an unknown substance, severely injured his kidneys, and then dumped him after 2 days back at his place of residence. So what is emerging in Zimbabwe in terms of what is happening is a clear involvement of the security forces in the abuses, a clear refusal by the authorities to take responsibility or to hold accountable those responsible. So, for example, we have repeatedly had the ZANU-PF, ruling ZANU-PF party spokesperson going public in press statements saying that they are not responsible. We have had the Minister of Information, Monica Mtrangwa, also denying any culpability by the state and saying instead that these are fake reports. So this is again, this brings us back to the need to, raise the standards in terms of information gathering and in terms of making reports, because the default position by the government is denial, and there is no room really for any prosecution locally because the courts are compromised, they are not independent, and they do the bidding of the state. The same applies to the prosecution, the same applies to the police, who appear to be sort of subservient to the military in the operations. And wherever there are protests, peaceful protests even, the military is deployed on the streets and they commit a range of abuses. Back in January 2019, more than 17 people were shot and killed on the streets, and there has been no accountability. If we go back to another case of the 1st of August 2018, 6 people were shot and killed by the security forces on the streets of Harare, and yet there has been no accountability. President Mnangagwa set up a Motlande Commission of Inquiry into that violence, which found that the security forces had been responsible and called for action and justice and accountability on the part of the perpetrators. But since December 2018, nothing has happened. There is no movement. There is no willingness on the part of the authorities to take action. So clearly for Zimbabwe, as we move forward, and as Human Rights Watch, we are also now convinced that there is no space inside of Zimbabwe for justice, for human rights respect, for accountability. And we now look to beyond borders of Zimbabwe, to South Africa, for example, for accountability, for the application of the universal jurisdiction to the United Kingdom, for example, because there is simply no domestic remedy that is available inside of Zimbabwe. So on that note, I'll stop and then take questions. Thank you.
Thank you, Dua. I think you've reminded us why we're all here tonight, why there are so many people interested in listening to us, and why we are looking to universal jurisdiction outside Zimbabwe as very much a last resort. I think we have somebody, I think we have Tawanda here. I think he's out and about, so I don't know if he's able to call in now. He had some questions. Tawanda, are you there? Can't hear you at the moment.
I think, yes, Sue, before he comes in, there's one question that was raised from the floor. Someone, there's a question.
Okay, Tawanda's trying to speak at the moment, Simba, but he's not got a very good connection. So maybe you do your question first. Tawanda, can you hear me? Do you want to do your question now? Or if we can't hear you, maybe you can type it and then we'll pass it on to the speakers.
I hope you can hear me, Sue. There's a question that was raised here from the floor.
Yep, go ahead. No, I didn't hear it. You were on mute. You were on mute. Can you do it again?
I apologize. Yes, someone asked from the Facebook page and said, they said, why not just go to the ICC? Why are we debating all this universal jurisdiction and having to stretch it to different countries?
Kajal, do you want to answer that?
Yes, sure. So Zimbabwe is not a party to the Rome Statute, so they cannot, the International Criminal Court cannot subject Zimbabwe to any international charges, bring individuals from Zimbabwe to face charges there. But that doesn't mean that on the basis of universal jurisdiction, we can't do it in our countries. It's just that they cannot be brought to the ICC.
Thanks, Kajal. Tawanda, can you hear us now? Are you able to ask your question?
Yeah, I can hear you. Can you hear me? Okay, thank you very much. First of all, let me appreciate the efforts of everyone here to ensure that there is freedom and justice in Zimbabwe. I have a few questions here. The first issue is the issue of reparations, that the victims of torture in Zimbabwe, in particular, Joanne Netsai, Cecilia, and recently Tawanda Mcheyiwa, and many others that Mr. Dewa mentioned. Is there any pathway for them to get reparations paid to them one way or the other? Obviously, they cannot get that done in the Zimbabwean courts, but can it be done in other courts outside Zimbabwe? And then there's the issue of aiding and abetting these terroristic activities that are being perpetrated to the Zimbabwean people by the Zimbabwean government. Countries like South Africa, President Cyril Ramaphosa, and others, they seem to clearly support what is going on. Can we file cases against anyone who is aiding and abetting this kind of inhuman behavior? And then the last question is, I've heard a case saying it's difficult to get or it takes long to get jurisdiction in these cases. Is there anything that can be done meanwhile, while we're waiting for the cases? Can the lawyers or any outside court write to the perpetrators of this violence so that they are not able to attend meetings outside Zimbabwe or international conferences? Because personally, I don't think it is right for Britain as a country or the United States of America or any of these countries to be hosting these people that are known perpetrators of violence. Can something be done while people are waiting for the final jurisdictions? Thank you.
Very much, really interesting questions. Kirsty, do you want to start? I'll let you choose which question you want to answer.
Thank you very much for the questions. On civil jurisdiction, which is the first one on reparations compensation, there's not been much movement in jurisprudence internationally in getting any civil reparations for somebody who is basically complaining of a universal jurisdiction crime. The most recent judgment that I'm aware of was a European court. So looking at Europe, there's a European Court of Human Rights decision. The case is Ney Liman, and it comes from Switzerland. I think it's a very flawed decision, but that considered where the applicant who had alleged torture in Tunisia was in Switzerland and became a Swiss citizen, but obviously after the events complained of, try to access the Swiss civil courts to get compensation from the alleged torture in Tunisia, and lost in the Grand Chamber in the European Court, in the regional court, on the basis that there was no denial of access to a court because the person did not have sufficient connection with the state. So what you have here is this balance between the universal jurisdiction rights of victims and state sovereignty. And I think they got the balance wrong there. They just looked at the state itself. So I think it's right to be developed. There's been a similar attempt at a domestic court here to our Supreme Court, which wasn't successful. So you're really pushing it against it internationally, and you'll be creating new law. I could probably hand over to others. Some of it's campaigning on the last point you make on preventing of traveling and so on. And there are developing sanctions actually, which others may be able to touch upon, the Magnitsky laws, which are starting to be brought into force in different countries. But I'll hand over to others.
Kajal, do you want to go next?
Yes, thank you. It is also possible to proceed on individual cases to sue for civil damages in Zimbabwe. There have been some cases which have been successful. The one case which comes to mind immediately is that of Justina Mukoko, who was abducted and disappeared many years ago. And as a result of huge outcry, she was brought back, and she has successfully sued for damages and has been paid these civil damages. Another case which is not related to universal jurisdiction and crimes against humanity, but rather it was a transgender woman who was arrested and strip searched to verify her gender, was also, this is the case of Ricky Nathanson, who was also successful in suing for civil damages. So on an individual basis, it is possible to proceed in Zimbabwe in domestic courts, and some domestic courts have proved to be quite progressive. So there are still some judges with the measure of independence who can be relied on. But if we're looking at a big picture of reparations, I can't imagine that you'd be able to proceed domestically in Zimbabwe.
Dua, did you have any thoughts? Dua?
No, thanks. I fully agree with Kajal. That's what's happening, and there are possibilities inside Zimbabwe, and some have pursued those. Yes, thanks.
Okay, I just want to come in on the last point, which is Kirsty referred to a new law, which has been known as the Magnitsky Law. We have got a version of it in the UK, which means that the government can, or the Foreign Office can decide to put sanctions on foreign officials or and exclude them from the UK. So, for example, they've done it in relation to the Saudi Arabian officials who are thought to be involved in the Khashoggi horrific murder in Turkey. So it's possible for NGOs to write to the British Foreign Office and ask them to exclude Zimbabwean minister, for example, on the basis that they've been involved in egregious acts. I don't know if that's going to happen in South Africa as well, but you know, obviously it's not as strong as a prosecution for universal jurisdiction, but it's something that can be attempted.
And just as a follow-up question,
in South Africa, but the one thing which has happened in South Africa recently, which everybody will remember, is with the case of Grace Mugabe, who is now prevented from traveling to South Africa because of domestic criminal charges. So, you know, some things are possible, but it does require action. It does require reporting. It requires people to open cases and to actively be opening cases and to be making complaints about individuals.
Tawanda, did you have something more to add?
Just a follow-up question on the victims of torture in Zimbabwe. Is there any relief that can come their way in terms of removing them from the traumatic environment that they are living in? Because these people that have been tortured continue to live in the same environment. They continue to see their perpetrators moving every day without any retribution. They continue to see people in army uniforms and in police uniforms, and those are the same people that would have perpetrated violence against them. So is there any way the international community can assist those individuals to be removed from the traumatic environment?
I think that's you, Kajal.
Under normal non-COVID circumstances, it is possible to have people removed from Zimbabwe, and this is mostly on a temporary basis, where they can be removed to another country to receive medical treatments and psychosocial treatment. If they wanted to move permanently or semi-permanently, they'd need to seek asylum, which is a longer, more involved procedure. However, with the COVID-19 lockdown restrictions, it has been extremely difficult to move anybody, and in fact it's been criminalized, so it's impossible to move people outside of Zimbabwe. You can relocate them internally, but not possible to cross borders at the moment. But once COVID restrictions are lifted, it is possible to both temporarily and permanently relocate people who, depending on what their individual circumstances are.
I just come in, Sue, on I was just thinking just to kind of give a headline on universal jurisdiction considering criminal, and also when you consider civil. I think if you keep in mind that the states that recognize universal civil jurisdiction are the exception, that will help you when you're really looking at where to go. So I don't know if that's quite just a good summary, because I obviously delved into the Swiss case, and it's fairly complex, but it's just not universal civil jurisdiction. Just is not moving forward currently.
Okay, thanks. I think we are almost, well, we're over our time, but were there any final questions? I don't know, Simba, if there were any final questions that, or
yeah, I've got two questions here. One came from Comfort. Comfort wanted to come in. She wanted to join into the Zoom, so I referred her to. Comfort is based in the US, and I referred her to the Zoom link, but she hasn't. I see she hasn't requested. But I will just ask her question that she texted me. Was on complicated cases that involve killings using accidents, for instance, those type of complicated cases. Is there a possibility of them being included on universal jurisdiction consideration? That is a question. Number two, we have other things that are done by people who are in organizational authority. Like, for instance, let's say someone who is working for the UN. We've got a practical one where and involves the Interparliamentary Union, where we've got an individual who literally lies on camera that he is not saying that he has not received any reports of abuses against MPs, and literally lies. And follow-ups are done via email, follow-ups are done physically, even to their offices, and all that filmed. And you can see that there is an evasion, a literal action, physical activity going on in the area of trying to stop the will of an investigation, or the will of justice in this case. And I know such a case there would appear as if it's administrative, because it could be said here, look, this is an administrative error, or it's an administrative failure. But can that not be included as a crime in the area, as Tawanda there was asking, aiding and abetting? So two questions. I'm sorry, the second one was a bit too long.
Okay. So Simba's asking, first of all, what if the murder's presented as the kind of accident? Might it still come within torture or crimes against humanity? And then the second question is, if there are officials who are involved in failing to act on torture, covering up, ignoring, etc., is there anything that can be done about that? Kirsty, do you want to come in?
Yeah, I think, again, both questions are really interesting. It's necessary to separate evidence from defence, and a usual defence is it was an accident. But if the evidence is showing otherwise, you're a deliberate act, deliberate killing, you're then coming within one of the physical acts which would make up a crime against humanity, if it's a killing, or if it's a torture. Then you would be looking at the context. So physical acts, then look at the context. And the context is whether it's committed as part of a widespread or systematic attack directed against the civilian population. So widespread, it can be just a huge number. So if you've got a huge number of so-called accidents, then which actually aren't, or even if you don't get, you have the inference that you're just simply not likely to get 100 accidents within all these prisons at this time, you're going to be coming within a crime against humanity. If it's, or the other part is, or systematic. So that means that would generally exclude something that's accidental or isolated. But basically, if you're looking for a pattern, and it can either be numbers, geography, systematic is given its natural meaning. And so what I would say is, you have a case of an accident. If there's nothing else, no other cases around that, say in that prison or in the area or during that period of time, you are looking at perhaps one murder or one particular crime against that individual, which in itself is serious, but it would not come within a crime against humanity. If there is a pattern, it's widespread, numbers, geography, so on, then crime against humanity.
Thanks, Kirsty. Kajal, anything to add? And can you say anything about the cover-up situation, where It's just that officials aren't taking action, so they're complicit, but they haven't actually committed those crimes themselves.
Yes, and it all comes down to evidence and what information is available and what these individuals know. But what I would recommend for people who are finding this kind of difficulty is that there are many avenues to lodge complaints. There is African Commission complaint system, there's the UN special procedures, there are a number of complaints handling procedures, and I think if there is a volume of complaints that they cannot be ignored and that there will need to be an investigation or at least an official visit from these UN special procedures to Zimbabwe. And I do think there needs to be a volume of complaints on all of the cases which are ongoing and which have happened in the past years.
If I just add on the UN special procedures, I would say, I think just picking up on that question, I would say that there's always a big debate in the international community, as you will know, Sue, as to how effective they are, because ultimately you're getting reports, and it's been referred to, often you'll get denial from a particular state that it's even existing, that these acts are actually taking place. But the importance of them is you will get some findings from a UN body, which then activists, NGOs can rely upon as independent evidence that they can put forward. And there are some parts of the UN, such as the Committee on Arbitrary Detention, which has additional powers to simply writing a report. They actually have powers to go and visit. And I found that particular committee to be effective in that it can actually be apply for permission to visit the country, to visit the prisons, to then investigate themselves the reports on torture and the reports on the conditions of detention. And each step of the way, it's adding more pressure. Countries like Zimbabwe in the past, I'm not up to date on the situation. It's a while since I've been in Zimbabwe, actually carrying out human rights training there. But there was a time when all the special rapporteurs were being stopped from actually entering Zimbabwe. I don't know if that's still happening, but that is one aspect that could form a lobby group, that if the UN is being blocked, then that in itself could form a basis of lobbying, because the reports themselves, it still is part of the international law system. And although what you end up with isn't actually binding in terms of a decision, it still is international law, and you have a state which has ratified the various treaties and agreed not to act contrary to international law.
Okay, thank you very much. I think I am trying to draw towards an end in the next few minutes. I wanted to highlight that on the Facebook page, you should be able to see the story of another person who's experienced torture, who's currently had to escape the situation, another opposition member, Job Sikala. So if you haven't already heard enough, then that is another story. But I'd like to give a chance to our two Zimbabweans tonight to have a final say, to Hilton and to Dua. I hope that those torture survivors who are listening in will have got some hope from this. I hope that people have got some ideas, and that we from all our different countries can come together to try and change the quite frightening, very challenging situation that has been happening for so long in Zimbabwe. We can see this is just a small step along the road, and that we've got a lot further to travel. But I don't know, Hilton, would you like to come in now? Have you got any further thoughts about where we should go? You're still muted, Hilton.
Can you hear me? All right. I was just wondering, the point on Zimbabwe not having ratified the ICC. I don't know what it means, honestly, because it appears the bad boy states will not ratify, obviously. That if the ICC cannot take up anything against them because they haven't ratified, they are sort of scot-free to do whatever they want. Is there is there nothing in these laws that can take on board what the bad boy states do?
Well, I think the best example is the US, isn't it? That also doesn't want to submit to the ICC. Yeah, there isn't much. That's why we're looking at universal jurisdiction as an alternative. Stuart, can I ask you to come in with your final thoughts about the future for Zimbabwe and those of us who are trying to support the struggle for human rights in Zimbabwe?
Yes, and thank you so much. And well, the ICC may not be directly applicable, but this is why it's important to look at universal jurisdiction, which is something that we are looking at options beyond and outside of the ICC. And I think this is a very good initiative, and I would appeal to the panelists, to SALC.
Well, the best example is the US, isn't it? That also doesn't want to submit to the ICC. Yeah, there isn't much. That's why we're looking. Simba, your play is playing back the feedback. Sorry, can you turn off the Facebook?
Hello, sorry, can you hear me? Okay, thank you. Yes, so my appeal to SALC, to Kirsty, to Sue, and others is that really we also need to find mechanisms. Kirsty, you spoke about training, human rights training. We also need to look at also training of information gathering, of evidence collecting, so that we can have solid cases that can be useful in terms of prosecution outside of Zimbabwe. We need this kind of evidence to be available, so that when we take these cases in the UK or in South Africa, we have solid cases. And to do that, we need people on the ground in Zimbabwe with the necessary skills. Someone spoke about the use of accidents or road traffic accidents. For example, there has been mention of Apostle Chiwenga in Zimbabwe, who has spoken of these attacks and road traffic accidents. We need evidence gathering that can help present a solid case. So the question of evidence needs to be addressed. Kajau has mentioned that it takes many, many years. So we need to have methods also of preserving this evidence in ways that it can be useful after several years. And some of these crimes, like rape, they also need specific and specialized ways in which you gather that kind of information. And we would appreciate that kind of support to activists in Zimbabwe on the ground, so that we can then begin to build a solid body of evidence to present when we deal with crimes against humanity. Thank you.
Thanks, Stuart. That's a great suggestion. I'm sure we'll take that forward. Kennedy, do you want to quickly come in with a final question?
Yeah, mine is just a simple one of trying to get your views on a strategy of also holding other countries, probably in SADC, accountable and also complicit to some of the violations that happen in Zimbabwe, given the fact that we've got like the UN instruments such as the United Nations Declaration on the Protection of all persons against enforced disappearances. People have been disappearing in Zimbabwe, people have been tortured in Zimbabwe, but SADC is just quiet, but they are obligated under these provisions to actually act, because these crimes are crimes against nations, and all countries should actually talk about it at least, or even act. So can we not just probably also be holding other countries accountable? And is that strategy a good one? That's the question.
Who wants to answer that? Kajal, any thoughts? Kirsty?
Yeah, the regional strategy, the SADC is a good suggestion. And of course, the SADC court itself was suspended because its first case was a white farmer case, and it was just the worst case for the fledgling SADC to take, because it was politically poisonous. And that judgment then led to the suspension, which was a lost opportunity for the region. I do a lot of work in Nigeria and West Africa, and the ECOWAS court, the regional court there, is effective but underused, and it's based in Abuja, bang in the capital in Nigeria. But a lot of the lawyers just simply don't think outside the domestic courts. So any kind of regional system that you can get moving and working is one which is likely to be a good one. And obviously that first judgment from SADC was a powerful judgment. And whether that's combining with South Africa, I mean, there's far more experts on this panel than me in relation to what could be done there to get a regional mechanism operating properly. The only other point I put forward is I draw to your attention Eyewitness, which is the Human Rights Watch app, and that has been, I'm trying to remember the case, it was actually this year or last year, but it was the evidence gathered on that app, which is there to protect people, so you literally can upload it and you're not identified, and it's stored in a way so that its origins can be certified sufficiently for use in a court, and that's really helped protect witnesses and successfully led to a prosecution, international crime prosecution, either this year or last year. So I'd really encourage people to look at Eyewitness as well.
Okay, I'm weakening. I've got one final question. We did talk about the question of when a murder's made to look like an accident a bit earlier, but I think you're specifically asking about it's not so much an accident, or it's made to look like an accident, but also evidence is contaminated by the police. Kirsty, I don't know if you can see this in chat. I think that's probably your area.
Of course. I mean, referred to, there's been a number of cases in Zimbabwe that I'm aware of that this is a method. It's when you're looking at a corrupt police force, it's always going to be difficult on evidence gathering, and that is where you are, as lawyers, you are reaching out for international partnerships to push on the evidence, because of the dangers that the lawyers will face. And over the years, I've worked with a number of lawyers in Zimbabwe, Beatrice Mtetwa, for example, and a number of others. So I'm aware of the dangers that people face. It is very difficult, and I think that's where you need to be really looking at what you can do yourself in terms of forensic investigation. If that was to be carried out in this country, for example, you would have an expert looking at the vehicle concerned. You would have expert reports on have the brake cables been cut, and then the trial goes from there. And then you're then moving outwards to see who had access to the vehicle, etc., etc. I appreciate that it's not quite as straightforward in Zimbabwe.
Okay, I think we want to draw this evening to a close. I hope that those who are watching us on Facebook have found it useful. It certainly is important to be talking about these issues and working together on them. I think tonight we've exchanged a lot of useful information. We've got the idea about training, we've got the possibility of using sanctions, but most of all, we've got the slow building blocks, which are very much started in South Africa with their fantastic example and are still continuing there. And hopefully we might be able to develop in the UK of calling ministers to account for the appalling human rights abuses that have been taking place in Zimbabwe, like the cases we've heard of from Human Rights Watch and from Hilton Tamangani and others. And I think keep an eye out on ZimEye for what happens next. Thanks very much to Simba for organising it, and particularly thanks to Kajal, to Dua, to Hilton and to Kirsty for sharing their experience and giving up their time this evening. Thank you.
Thank you very much, Sue, and thank you very much all.
Thank you, Sue, and thank you, ladies. Thank you, everyone.
Thank you, everyone.
Just what we have been waiting for all